City Council work session. Today is Tuesday, July 26, 2022, and the time is 5:34 p.m. We'll start with item A on our agenda, the introduction of Noah Peterson, our engineering intern.
Honorable Mayor and City Council, I'd like to introduce Noah Peterson. He's been our summer engineering intern. Unfortunately, we're losing him on Friday as he's going up to Denver to graduate school, but he's been a big help. We've had him do everything. He's worked at the water plant, he's done refuse collection, he's done cost estimates, you name it. He's worked on our capital projects, done surveying. So with that, I'll turn it over to Noah.
Howdy. I get to be item A. That's pretty cool. Brian said a little bit of it, but I just been doing kind of a jack of all trades thing, and they let me run an excavator and got to clean the clarifier over at the water plant, and they let me use a dump truck too and move some dirt, and that was a good time, and got to hang out with the asphalt crews over at D&L Construction and do a little bit of that and push some asphalt around, and yeah, concrete work, just a little bit of everything here and there, but it was a good time. Learned a lot, so yeah.
Great. Well, thanks for coming tonight, and appreciate your service to our city, and I think it's a great experience. You get to try a lot of things and see how it works. That's what's nice about a small community. Are you from here then, or?
Oh yeah, I am.
Okay.
Mm-hmm.
Who's your fourth grade teacher?
Who's your favorite teacher, I think he's asking?
Your favorite fourth grade teacher? Oh wait, there was only one. Okay.
Right.
We didn't get to use dump trucks as much as we would have liked to, or do asphalt or concrete work, but
Those big excavators and all that good stuff.
maybe next time.
Yeah, next time, right?
Well, thanks for coming to our meeting and introducing yourself, and good luck with school this fall.
Yeah, definitely. Thank you guys. I learned a ton. It was a good time.
And come back to Cortez.
Yeah.
Will do, definitely.
Yeah, we're hoping he comes back next summer, but I don't know. He's pretty talented, so we'll see.
Great. Well, thank you, Brian. Appreciate you bringing him here so we can introduce, or meet Noah, so thank you.
Yeah, thank you guys. Appreciate it.
Thank you.
All right, we'll move on to item B, a presentation from Sam Light for Sursa General Counsel. This is our city insurance. And
Thank you,
thanks.
Honorable Mayor Medina, council members, staff, for having me up this evening. So my name's Sam Light, and I'm General Counsel for Sursa. That stands for the Colorado Intergovernmental Risk Sharing Agency. That's a mouthful, so we just call it Sursa. And we are the city's insurance provider for property and casualty coverages. A little bit about Sursa. We're not a commercial insurance company. We're a public entity self-insurance pool. Red light, green light. There we go. Go. Excellent. I'll repeat that again in case there's folks out in the virtual world, right? That's what we do these days, things out there in the virtual world. So I'm Sam Light, General Counsel for Sursa, which is the Colorado Intergovernmental Risk Sharing Agency, so we just call it Sursa. And we're your property and casualty insurance provider. Sursa is not a commercial insurance company. We're what's called a public entity self-insurance pool. Our only book of business, our only members are Colorado cities and towns and affiliated entities like housing authorities or renewal authorities, and so on. So we're very proud of that. We're owned and controlled by our members. Our board of directors consists of local government officials here in Colorado. The city of Cortez, you've been a partner with Sursa since 1995 for property and casualty coverage, so we appreciate your membership and we value our longstanding relationship with the city for your property and liability coverages. Just a little bit more about Sursa to give you a sense of our size. We have 282 members in the insurance program, about 280 in our property and casualty program. So I like to describe it. One of the things we do at Sursa, obviously, is what I call the bread and butter stuff, right? We make sure that you get your coverages in place each year, deal with the renewals, deal with all the paperwork that comes with insurance. We also have this other department called the Claims Department, right, that handles claims when they come in. But we also, being member-owned and being close to our public entity partners, we have other resources for you as an organization that are there as much or as little as the organization would like to use those resources. As an example of that, that's tonight's training or presentation is an example of one of those services that we provide, is doing presentations around liability and risk management for elected and appointed officials. So my presentation tonight is organized around what I call suggestions for success. As elected officials, kind of suggestions to help you as the elected leadership of the organization succeed, talk about some commitments that we make individually and collectively when we become elected public servants. And I think that if we embrace kind of these suggestions for success, then, you know, by and large, the corresponding risk issues are going to take care of themselves. A couple of housekeeping items I put at your places, some handouts that I'll mention as we go through the materials. One of the items that I put at your places was CIRSA's Ethics, Liability, and Best Practices Handbook for elected officials. It's a publication that we first put out in 2015 and then republished in 2019. And it covers a bunch of issues around risk management, we hope, from you know, an elected official's perspective, kind of puts on your radar some of the risk issues that are important for you as the governing body of the organization to have, you know, not on your mind every day, I hope, but to have there in the background as some principles that are important to appreciate. So I understand we've got some newer members of council, is that right? A couple of people who were recently sworn in, congratulations, and then some familiar faces that I recognize. So whether you're brand new or in the middle of your term or got a couple terms behind you, I hope that my presentation is a helpful resource to you all. We're going to talk about the role of public official. We'll talk about organizational structure and liability, that concept of how everyone within an organization has a job description and how that influences risk. We'll talk about transparency, the expectations and the obligations around transparency in Colorado for public officials, primarily the open meetings law. We'll talk about that. We'll talk about ethics briefly. You know, when you were elected, you became subject to the Colorado State Standards of Conduct that govern ethical conduct by elected and appointed officials and public employees here in the state of Colorado. So I'm going to talk briefly about that, touch on just a couple of issues. And then talk finally about due process, which can be a training, probably a multi-hour training in and of itself, so we won't do that tonight. I know you've got other things to move on to, but I want to get a couple of concepts on your radar around due process, because there are different expectations that apply around this issue. You know, one of the very interesting and awesome things about being on the governing body is you wear a couple of different hats, right? Sometimes you're legislators making general policy, but other times you make decisions that affect individual applicants, right? Whether it's a land use decision or a licensing decision. And we're going to talk about why that's significant from a risk standpoint. So just a couple of final housekeeping comments or preliminary comments. My presentation is a training resource only. Though I am an attorney, this obviously is not an attorney-client communication session, and I do want to make the session as helpful to you all as possible. So if you have questions as I go through my materials, please feel free to interrupt and ask questions. Subject to this caveat. So before I joined CIRSA about 3 years ago, I did what your city attorney, Patrick, did. I did that for about 25 years. I was a city and town attorney. Did a lot of trainings, and again, ask me any questions that you want, but I have what I call a pretty good radar for what I call the live one, okay? So you can ask any question that's on your mind, but sometimes the dynamic might be this. Sam, I've got a question. What if another member of the governing body does this, right? And everyone's eyes open wide, and well, this is going to be an exciting discussion, right? That's when my radar is going off, telling me that that might be the burning issue of the day here and now in the city of Cortez, right? So I'm still happy to give you some risk management suggestions from our perspective at CIRSA, but if you need legal advice in the here and now for issues that you've got going on, that's for your city attorney's office. Same concept for administrative matters, right? I may give you some input from CIRSA's perspective, but if it's an administrative matter, you want to look to the support and guidance of your city administrator and his team on that issue, okay? All right. So again, I've organized my presentation around commitments or suggestions for success, and my first commitment may not sound like it relates that much to risk management, but I really think it does, and that's commit to the role of being a public official, right? When you became an elected official, your relationship to the community changed dramatically, right? You're no longer just a citizen of Cortez, you're now a government official. That's a 24/7 job, right? I'm not saying by that, don't give up your personal life. Please enjoy it. Please have one. But the way it translates into risk is when you're interacting with your citizens and your constituents, particularly the ones who are in the know and know you're on city council, and particularly when they're engaging with you about city business, but not exclusively, right? They will always perceive you to be, right, an elected official, a representative of the council as an institution, and a representative of this organization. And of course then, as they should, your words, your deeds, your conduct matters, has effect, leaves an impression. If someone that you're interacting with thinks that interaction didn't go so well, from their perspective, it leaves a residue. And in a worst case situation, right, by our own words or conduct, we can create liability risk for ourselves or for the organization. So I think it is important to keep that on. The mayor knows this all too well, right? It's the 10 o'clock phone call. It's the bump into you at the supermarket. You're all going to be, if you haven't already, right, you're going to have that experience. And even when you bump into the citizen down at the city market, you may tell them over and over, this is my personal opinion. This is just my personal opinion. What are they filtering? Council member, council member, council member, right? So they will always perceive you to be an elected official. I think that's an important aspect of committing to the role that you volunteered to take on behalf of your community. Recognize also you're no longer an outsider to local government. You're now all the ultimate insiders. And it has an important risk dynamic, of course, because of this. When in local government, we have, as you do, a lot of ordinances and resolutions and rules and policies and procedures, right, that govern the way we do business, both procedurally and substantively. A lot of process rules and a lot of rules that are set the standards for how we make decisions. And now that we're on the inside, those things stick to us, right? And we don't have the luxury, right, of taking the attitude of, well, that rule doesn't apply to me, or I never liked that rule, or I'd like to go a different direction. There is a risk component around that, so it does require we embrace that insider's perspective. Additionally, being on the governing body, the dynamic sometimes when you run for office is that you want to stake out your issues, but that may be a smaller number of issues, right? You may be a critic or a proponent of a particular issue or a particular handful of issues when you're running for office or seeking office. But now that you're on the inside and you're an elected official, the charge, the role is broader than that, right? And you're now elected to be, a great representative. Do you have wards? I forgot to check. You're elected from wards, districts? You're all elected at large, right? And so part of the responsibility is to be a great representative, right, on behalf of the entire community with respect to all of the issues that come in front of council. I know some of them may not ultimately be your favorites, right? You might have more interest in the development and growth issues, or water and utility planning issues, or you may be the person who loves the audit and wants to volunteer for the audit committee. But whatever it is, part of the job is to commit to be a great representative for all the issues that come in front of council and to be an ambassador of the organization. And that's a great way to look at your tenure, okay? Also, whatever the relationship you had with the organization before, as the elected leadership at the governing body level, that highest level on the organizational pyramid, you're just like the corporate board of directors, because you are. municipalities are corporations, and you're analogous to the board of directors of a corporation. We just call it the council. In that role, right, your primary responsibility is the protection of the city's best interest and assets at that highest level. You're the guardians, the stewards of this organization as an entity, right? Fiduciaries of the city. And so kind of staying at that 40,000 foot level, maybe a guiding principle for decision making is always, what's the right thing to do for the city as a city, right? That's not always easy, right? Right? Sometimes it's going to be difficult. And sometimes you're going to feel like you're under a lot of pressure to make a decision immediately. Or maybe you've got a situation where during public comment, people are coming up and telling you, counsel, you need to do this now, or this is an emerging issue that but you're thinking to yourself, well, I'm just hearing about this issue for the first time, or this is new, or we as council haven't had a chance to talk about this issue together, to deliberate on it, or understand from staff what our options are, or what we as a city have already done. So I think as council and as council members, it's always your prerogative, right? And I would suggest to you, take the time that you need and get the information that you need that will help you make decisions that, hopefully meet these principles, right? Not always going to be easy. Sometimes you're going to get there by a 4-3 vote. Sometimes it's going to be a 7-0 vote, right? But whatever it is, you want to work towards those broad decision-making principles. Our new folks, we all took the oath of office recently, right? We got that? We got that? Okay, because you have to do that within a certain amount of time after you get your certificate of election, right? Your oath of office may not be on the forefront of your mind, but there are some principles embedded in the oath that I think have meaning for you legally, ethically, morally, which are pretty important, and it's good to check in on those. I think the oath of office, right, includes, among other things, these core commitments: a commitment to respect your role and responsibility in the organization, right? A commitment to lawful conduct. I swear to uphold the ordinances and the charter of the city, including following the city's rules, procedures, and criteria in making decisions. A commitment to ethical practices, as I mentioned. And then this last one may not sound, this last bullet on this last slide, may not sound like it falls that neatly out of the oath, but I think it's there, at least implicitly. When we became an elected member of the governing body, we were elected to contribute our voice, right? Our 7 different perspectives and viewpoints and experiences in terms of helping the entity, the institution make decisions. But at the end of the day, the council speaks with what? One voice, right? Ultimately, the citizens' interest is, what did council decide? What is council's position, right? And with a multiple member governing body, you're always working towards, right, consensus building, or trying to get members to come to your side, or expressing your viewpoints. And I think in that dynamic, what it requires or asks of us as part of the oath is to have, professional courtesy and respect for each other's divergent viewpoints and opinions, appreciating how our colleagues at the dais may have different styles of approaching a debate or deliberation, always ensuring that everyone contributing to the discussion feels like they're in a safe place and has equal opportunity to contribute to the debate. I think those are very important aspects that a wise council recognizes and embraces in terms of working towards the we and doing things that make the institution of the council stronger. No matter how difficult the issue, or no matter how divergent the viewpoints are on how to handle an issue, that ultimately you work towards that decision, you take that decision, right, and everyone says, I respect that decision, and we move on. But I do think it requires courtesy and respect for each other. New members in particular, but as a reminder, a question for the ones who've been on council a lot for some time. Who likes process? Do you like process? Yeah, you have to in this role, right? We kind of get a bad rap sometimes in local government. Oh, it takes so long to get things done in government. Well, that's intentional, right? Because we're making important decisions on behalf of our community. Yes, it can be frustrating sometimes, right? But we have to like process. And in fact, process is one of the products in and of itself that local government delivers, particularly at the governing body level, right? You as a council provide a forum right here and a way for community members to come and express their viewpoints on the needs and wants of the community. And then at the top of that organizational pyramid, you get to make decisions on how we put governmental resources on those wants and needs. But embrace that process in and of itself. Right? There's going to be a job where you're not going to make 100% of the people happy 100% of the time. But faith and trust in government goes way up if even in those difficult situations, people walk away and say, that was a good process. Right? So that's very important. For everyone in the organization, but for elected and appointed officials in particular, I think one of the job responsibilities is also to deliver good governance, right? Which ultimately I think depends on committing to a couple of core civics principles that I've listed on the left-hand side of the slide here. And I think if you commit yourselves to those individually and collectively, that by and large the corresponding risk issue is going to take care of itself. So by that, for example, commit yourself to openness and transparency, and you'll have few, if any, disputes, claims, litigation over compliance with the Open Meetings Law, the Open Records Law. I'll get into this more later, but do we recognize in this service of transparency, for example, that we use email to do our job as elected officials, right? Yeah. That by and large, those emails that you send and receive, right, to do your job as an elected official or that involve public funds, those are a matter of public record. Open to inspection by anyone who goes to the clerk's office and asks, pursuant to the Colorado Open Records Law, for all council member emails relating to this. And we have an obligation to produce those. So I think in service of transparency, it runs a couple different directions, but it's recognizing that when I use those kind of tools, right, there's going to be a transparency expectation around them. And it requires us then, I think, also to be a little circumspect in how we use those tools, recognizing that maybe one of us decided we were going to write an email to one of our fellow council members. That's not an open meetings problem, right? But we understand that ultimately somebody else may be reading that email that we didn't anticipate when we wrote that email. But now you will anticipate that potential, and that's just part of the service of the requirements around transparency. Commit yourself to fundamental fairness, right? And a few, if any, claims or situations where someone's saying, you violated my due process rights, right? That, at your level in the organization, that these kind of situations usually come up when you're dealing with a decision affecting someone's property rights, their interest in their land or their interest in a license. You don't do that all the time, but sometimes you do, and sometimes something's going to come up. Someone might stand up here at the podium during the public comment portion of a public hearing and raise a question or concern about process, right? To give you kind of a silly but hopefully somewhat illustrative example. Someone stands up and says, the mayor is called for public comment during that land use hearing. Yes, Mayor, I object. I didn't get notice for this hearing. I always thought that was a little odd because they're there. So, well, that's kind of the easy one. Okay, well, you got notice, but maybe they're making a more substantive objection about notice that was published, or there was some defect, or we didn't meet the time requirements, or maybe they're saying that we need to handle some documents in the proceeding differently. For those situations, I think it's your prerogative, in a certain way, your responsibility as well as the decision makers to sort of slow that down and say, okay, let's check in with staff. Manager, attorney, clerk, do we have proper notice? Do we have anything we need to do differently given this concern that's been raised about process, right? And always check in and feel comfortable. Once you've confirmed you're on good footing, then you can proceed. Commit to being predictable and even-handed. You have got a lot of ordinances, right, that set standards on how we make decisions. It's all throughout that city code. We got standards for marijuana licensing, liquor licensing, how we make decisions on subdivisions, rezonings. Those are all decisions you make, is that right, on those matters? Sometimes those rules don't work out exactly as we had liked. This is quite often the case if it comes up at all in land use matters. Sometimes you have a land use hearing and the staff says, and you have your evidentiary hearing, and all the evidence and points to, yes, this application is eligible for approval, it must be approved. But later on, afterwards, you're thinking, wait, I thought our development rules or our rules actually were not going to lead to that kind of result. that maybe it wasn't the type of project we thought we were going to get under our land use rules. Well, that's okay. You can change the rules within a proper legal framework for later, but you don't want to be a council, right, that gets a reputation or a vibe for changing rules on the fly. The most concerning thing, it's concerning from a lot of perspectives, but perhaps for the applicants or business community who come in front of you, if one applicant thinks to themselves, well, submitted my application and went to council, it was easy peasy. The criteria were straightforward, the hearing process was simple, I got my approval, but someone else feels like they're in the same boat. Maybe it's a special use approval. Is that what we call those, staff? Is it a conditional use permit or a special use permit? And you've got one of those in front of you, and that applicant comes and they go, well, that's odd, because I feel like there were these different application requirements that aren't in the code, and I feel like there were strange things going on at the hearing, but most concerningly, that night, when my application was up, that's the time that the council took a novel and unprecedented interpretation of their standards, and I got turned down. That sounds like a risky place to be, right? It can be frustrating if the rules weren't working the way you thought, but if that's what's really going on, you need to set that aside and say we have to consistently apply the rules that we have for this application, and then we can look later at a policy or legislative process to revise the rules. Finally, my last bullet on this slide may not sound like it's a predictor of risk, but I think it really is. Mutual respect goes a long, long way. Mutuality of respect with each other as council members, with the staff that you interact with the citizens. Right? Because as I mentioned earlier, you're not going to make everybody happy 100% of the time. But if you have one of those tough decisions and the room's full one of those nights and it's a split vote and emotions are running high and you're getting all sorts of direction about what you should do during public comment, if somebody goes home from that and they say to themselves, you know what, I get it now. Council's got a tough job. They had to take all that information, all those differing opinions, they had to wrestle through the standards, come up with that one decision. If that citizen's thinking to themselves, but you know what, I still disagree with what they decided, but you know what, I feel like it was a good process, right? I feel like I was heard, and I feel like I was respected. Faith and trust in you as in council members, the council as an institution goes way up, and your risk profile goes way down. Because it's not all the claims that we see at CIRSA, but there are certain claims that do have a flavor that runs the other direction. It's where the person goes home from that and says, not only do I disagree with what they decided, but I feel like the decision was already made before I got there. I feel like there were strange things going on with the hearing. When I stood up to speak, I feel like I wasn't heard or I wasn't respected. Those are people that often at times may be so mad that they say, I'm so mad about it, I'm going to see if there's some way to challenge that decision, and then we're potentially off to the races. They may not have a cognizable legal claim, but their blood is boiling to the point where they want to try and do something about it. And the underlying commitment there is partially mutuality of respect with everyone who comes before you. All right, let's pivot a little bit and talk about organizational structure and liability. This is a fair question, but I hope it wasn't your first question. New folks, I hope your first question to Patrick was not, can I get sued in this job? But the answer is yes, right? So I'm going to talk just at a 40,000-foot level about the protections you have and then kind of the limitations on that, because it is a fair question, right? And to encourage public service, all right, by local government leaders, we got to have some good protections under the law, right? Otherwise, it's too risky, right? So here, I'm going to just stand at a 40,000-foot level on this, and I'm just talking about the issue of whether someone can bring a legal claim and try to hold you individually and personally liable for some act or omission as a council member, okay? So in Colorado, we got this nice statute called the Colorado Governmental Immunity Act, and what it says is that the city, and by extension, the city's insurer, CIRSA, will defend you and will pay judgments entered against you for acts or omissions as a council member. Good news. By the way, that also applies to appointed officials, employees, and even to volunteers. So that's good news. But there's a catch, right? And the catch is that those protections apply so long as we're acting within the scope of our employment and not acting in a willful and wanton manner, okay? So two interesting phrases. Scope of employment sounds odd from an elected official's perspective because you're thinking, well, I'm not an employee, so scope of employment doesn't apply to me. It does. That's just a phrase that's used in the statute itself, right? As long as you're acting within the scope of your employment, you're protected. That just simply means everyone needs to know and appreciate what their job description is. Everybody's got a job description, whether you're elected, appointed, full-time employee, or volunteer. Just the easiest of examples to illustrate that. This concept of allocation of authority throughout municipal organizations is pervasive. Use it to your advantage, use it to your benefit, use it to help you get things done and look good while doing it, right? But on the liability side, here's the simplest of examples. Within our organizational structure, within whose job description is it to make that initial decision on whether a business license gets approved or denied? Probably the clerk, right? Yeah. So whose job isn't it? The rest of us, everybody else, right? Same thing with whose responsibility is it to issue a red tag for a building if it's unsafe? Chief building official. So whose job isn't it, right? So that permeates the organization. Just recognize that those things are there to serve and protect the organization. It does have a potential liability risk in this regard, right? Sometimes, very rarely, but sometimes we'll get scope of employment claims involving elected or appointed officials that I'll talk about in just 1 second when I unpackage this other piece. So the protections are there as long as you're within the scope of employment and not acting willfully and wantonly. So what's willful and wanton conduct? Willful and wanton conduct is simply conduct that's intentionally undertaken, that's designed to injure someone's protected legal rights, and that's taken with reckless disregard for what their rights are. I got an even simpler way of describing it. I just call it bad stuff, right? And we all know what it is, and we're going to stay far away from it, and we'll see those storm clouds on the horizon long before they ever come over us, right? But it is a risk, right? And the risk is if the civil liability to some third-party claimant actually flows from a determination that you engaged in willful and wanton conduct, right, then the organization has no obligation to defend or indemnify any further against that liability. And your public official's liability coverage works the same way, right? Your public official liability coverage through CIRSA is basically an additional indemnity product behind the city's obligation to indemnify. And so that coverage says we will provide you coverage and defend you against lawsuits, right, subject to conditions and limitations. And the conditions is the insurance coverage is there to protect you as an elected official, in your capacity as such, or when you're acting within that role. But there are exclusions for, as is, self-evident and intuitive, there are exclusions for like criminal misconduct, no coverage for that, right? Malicious acts, or willful and wanton conduct. So recognize that those are the outer edges of the protections, and we can lose those protections in extreme situations where we're engaging in willful and wanton conduct. Tying all that up, here's the risk factor. So we don't get many claims in Colorado where people try to bring individual claims against elected officials for willful and wanton conduct. But in talking with our claims folks, here's probably the most common kind of scenario that gives rise to that risk, okay? It would usually be an individual elected or appointed official, okay, misperceiving that they have some governmental authority that they actually don't have, right? Throwing on that purported cloak of governmental authority and doing bad things to someone for the wrong reasons, right? Like maybe going after a business competitor, or trying to get even with a political enemy, or maybe conscripting a staff member who is also not thinking clearly on the issue, and conscripting the building official to go on a campaign to make sure somebody's business gets red tagged. That all sounds like bad stuff, and it is. So we know what it is, and we're going to stay far away from it, and we'll be just fine in that regard. But I do want to illustrate the outer edges of where those protections are. By the way, under federal law, you have a similar protection. You have what's called qualified immunity. I know that's in the news a lot these days, but you do have qualified immunity from suit, and don't have the risk of individual personal liability, right? So long as we are not, right, violating someone's federally protected rights that we know or should know about. So the natural question from where you sit is, well, how do I know? How do I know? How do I know I'm in a safe space? And that's where your staff is there to help you. But from where you sit, it's always your prerogative to ask that question, right? If we're debating options and we want to take some action and you're feeling like, is this something we have authority to do, right? You can ask your city attorney, where's the authority come from? What is that authority? Give your city attorney a little some grace on this when he says that wonderful lawyerly answer, it depends, right? Because it may well very much depend on the specific facts of the situation and what the objectives and objects are, around that goal. But, in getting to a comfortable spot from risk management for you all, it's always fine to ask staff, what's the underpinning of our authority to do this? What are our options? What's a safe course to take? And then we'll make a decision, okay? In no particular order, here's a couple of tips and suggestions around avoiding any problems around role discipline or scope. These may not all translate to third-party liability risk, but a couple of them are, respect the job description and stay within it. Recognize, what is the role of the council? Well, under your charter and your ordinances, it says council is the legislative body, the policy-making body. You're responsible for financial management of the organization at the highest level, annual budgeting, right? You do appoint and supervise a few employees that I'll talk about in a second. You have some responsibility for overall organizational structure, and you can see those are all top of the pyramid policy-making broad decisions, right? And that's where you're most uniquely situated. Who are the owners of our corporation? Our citizens, right? And you're at the top of that organizational chart doing that work, the ambassador, the resourcing, the supporting and resourcing the organization. I don't harp on it too much, but I'm going to get into it here in a minute. There is a recognized distinction in your charter and ordinances and other documents between policy and administration. And so the job description of the council is that broader stuff. You have the broadest time horizons in mind as compared to day-to-day operations. You're more thinking long-term planning. Where do you want this community to be in 1, 5, 3 years? Overall annual budgeting, long-term financial planning, capital planning, master planning, those kinds of things. Yes, you do make kind of what I call day-to-day corporate decisions involving the corporation's interest in assets, maybe buying and selling land or water rights or certain contractual transactions. But that's all broad governing body type stuff. And then your manager administration then serve to carry out your work plan consistent with the limitations that you've put in place. As important, understanding your job description, recognize where power has been allocated elsewhere, because that does serve and protect you, right? As long as everyone's kind of swimming in their lane, that organizational chart is very helpful to us at CIRSA in terms of protecting you from risk. Because once in a while, claimants can get a little aggressive and they'll make some claim, maybe it's an employment matter, and they start naming an elected or appointed official. Well, if everybody's swimming in their lane and there's actually no factual support for the concept, for the idea that this individual elected or appointed official was involved, we're going to hold up that org chart. And we're going to say, these people are not a proper party to that litigation because they have no role or authority in this process. Of course, this runs all directions within an organization. Staff also knows and must appreciate that certain decisions are reserved to the council as the legislative and governing body. An example of that, right? Who within our organization, whose job description is it to decide whether or not this entity takes on debt? You and only you, right? So there's mutual respect running around all of those issues respecting allocations of authority. You do, as ambassadors of the organization, I do know that as a very important part of the job is being out there in the community, being an ambassador, a champion, listening to people, understanding needs and wants, doing somewhat, I guess, what I call politicking, getting counsel consistent with the Open Meetings Law on policy issues. But recognize from a risk perspective that counsel, as an institution, acts, right? Acts only by meeting in this room and making collective decisions, right? So a very large part of your job you do primarily by meeting in this room, and exercising your responsibilities by voting in a public meeting. That's a good place to be from a risk perspective, because there's safety in numbers, right? And as your city attorney will tell you, there's additional privileges that attach to conversations that go on in this room when you're clearly and duly constituted as a legislative body or as a quasi-judicial decision-making body. There's legislative privilege, you have immunity in quasi-judicial matters as long as you're just focusing on the appropriate handling of that matter, so that's a great place to be, okay? That all counsels back to the thing I had mentioned about the one voice. There's a little bit of a risk or danger around the, taking the view that it's not a we type of power. Right? If you look at your there's not in your code any provision that I was able to find, and hardly any, except for the mayor's role as a presiding officer and executorial role, and there's nothing in the code that says that the powers of the council shall be exercised by one council member. It's a collective power, right? So sometimes there's that temptation of, but it's an inappropriate view to look at it in terms of, well, we got 7 members, I own 1/7 of that power, so darn it, I'm gonna go out and use it. That's a risky way to look at things. Always think in terms of we, the consensus building collaboration. Here's another warning sign, but it's not so much about third-party liability risk. Mayor, do you have during the council meeting an opportunity for each member to make comments or council reports? Like maybe near the end of the meeting, we each give a report? Yeah. A lot of our members do that. But sometimes, what if the dynamic is, yes, Mayor, I've got something to report. Since our last meeting, I did this. And everyone else on the dais is kind of surprised by it. You did what? Right? That may not translate into any third-party liability risk at all, right? But I do think that raises a potential issue for the council as an institution, right? And it's a wise council that deals with that kind of issue early and tries to have that conversation. Well, what are our norms of conduct and expectations as a council for how we represent this council as an institution and represent the organization, in between meetings? And I mention it because I don't want people to be surprised to the point where they actually think that the right way to approach it is a legal solution, because then we're in the risk world, and sometimes people do reach out to SIRS and they ask us, hey, SIRS, do you have any sample policies of how we handle this issue? I say, well, one of the ways to get at this issue is to engage in the process of discussion with each other so it doesn't happen in the first place, and just talking around norms of conduct, right? The other reason I mentioned is I want people to be protected if they, as you all, I'm sure you're all very busy in addition to what you're doing here now, you volunteer to maybe be a council liaison for some outside entity or some board or commission. So you, in between meetings, do things on behalf of the council. I want that person to feel protected when they sign up. Yes, Mayor, I'll sign up. Myself and another council member, we'll go and talk to this district or something. They ought to feel protected when they come back and say, well, we did, the two of us or the one of us went and talked, did what council asked. We don't want the reaction to be, well, that wasn't the position we wanted conveyed, right? So that is a kind of working point for council to pay attention to that issue so everyone feels supported and the expectations are clear around that issue. Maybe not much of a third-party liability risk. There are some individual aspects to role discipline, right? And positive impacts that come from recognizing a couple personal commitments that have to be made once in a while, even if we would have preferred not, right? It's obviously the case that the governing body is not 7 councils of 1, but it's 1 council of 7 members working towards the voice of council. It does require sometimes that we set aside our own personal agenda in service of the work plan of the council. Like even if I sought office and my campaign issue was I want to get on council and I want council to pass a new ordinance, so I don't know, restricting the number of marijuana establishments, lowering the cap or something like that. Well, that could be my legislative priority all day long, but if I don't have 3 other council members willing to come along with me, I have to be willing, right, to set that priority aside in service of the council's work plan. How about this dynamic? Maybe you don't have many of these, but do you have some split votes? If so, if you were on the short side of one of those votes, maybe it's a 4-3 vote and you're on the 3 side, it's always okay to tell your constituent, hey, I didn't vote for that one, right? Is that okay? What do you think? Is that an okay communication? I mean, yeah. Far be it from me, the sort of guy, to say you can't tell your constituents, right, the folks that you answer to in the community that, hey, I didn't vote for that one, but in service of the council as an institution, is it a different dynamic if the conversation is this? Well, I didn't vote for that item, but, you know, it was a split vote. It was a very vigorous discussion at the council level. I fought like heck for my perspective, right? But ultimately, council decided to go a different direction. We had a 4-3 vote. Council decided to take a different position, but you know what? I respect the position of council. Is that a different, that's a different dynamic to that conversation that makes the council as an institution stronger. And I do think that is kind of a responsibility of office to make the council as an institution stronger for the long haul, and that it's stronger even when we leave office, right? So individually and personally, it does require some personal commitments around our own conduct that I think are important to the success of the organization. Do you face this risk much? One last item on this. You're out and about in the community, you're talking to a citizen, and the citizen's saying something to you, and you go, council member, I've got this piece of property over here, I've got this issue going on, what do you think? And you're thinking, they might be reading a lot into what I'm saying, or depending on what I say, they're going to take it and run with it, right? So there's a little bit of risk around that. Just remind folks, you know, it's our obligation to remind them about process and kind of deflect over to administration issues that aren't really in council's wheelhouse. But you want to protect yourself as well, right? If they want to understand your position on a council matter, you can certainly still tell them, well, it's my personal view on a legislative matter. They're still going to filter council member, but remind them, hey, it's a group decision. It's going to come in front of council. I can't be certain of what the outcome's going to be because there's this risk that's certainly over my head. It's kind of a political risk of people believing that you assured an outcome. And there are things you can do around that to protect yourselves from that kind of risk. Okay. Last piece of all this is adherence to the organizational structure is particularly important in the area of employee relations and administrative matters assigned to staff. Now, on the personnel side of it, first, the council has a few direct reports, correct? That you supervise, but that's the attorney, judge, and city manager. Yeah, city attorney, judge, and city manager, and that's almost universally the way it's set up for almost every home rule municipality in the state. And that's a wonderful place to be, right? Because you've got the resources from where you sit. We've got the resources in the organizational structure through our charter that says we are a council manager form of government. We're responsible for policy and governance, and administration is responsible for effective administration of the organization. Use that to your advantage, but recognize that allocation also creates potential risk issues. It does mean, like, you know, use your manager as a resource and let your manager handle the administrative things, because that's what they're there for, to help you get your work plan accomplished by doing the day-to-day things. Except for those few direct reports, that means that elected and appointed officials are not employee supervisors, right? We all agree with that, right? And tying it back to my delegation principle, it means that our organization, right, by our own charter ordinances or personnel handbook, whatever it is, we have said that all responsibility for administration of personnel lies with the manager, right, and department directors and other supervisors downstream of the manager. From where you sit, what a wonderful place to be, right? Because, frankly, then when there's some employment matter that bubbles up, right, that's high profile and so on and so forth, what can you say? Not our issue. And the manager says, I got it. Have trust and faith in the system, that is the system. I was not naive around these issues. I was a city and town attorney for about 25 years, so I know sometimes there's a potential risk around this kind of dynamic. You know, maybe it's an employee comes up to you and says, "Psst, can I talk to you about my boss?" Do we have a ready response for that? Yeah. We love and appreciate our employees, but I, as a council member, and we as a council, do not get involved in personnel matters at that level. I would encourage you to speak to your supervisor or your department head or HR or someone who can help you with your issue. Now, Also, in my world, I hate to be so cynical, but I know that sometimes there are situations that have a lot of hair and warts on them, too, right? And same situation, "Psst, can I talk to you about my boss?" And before you can even say my wonderful suggested words to them, they say, "My boss is harassing me." Well, that's not what we're going to say. Well, I, as a council member, would suggest you go back and talk to your boss. No, we don't want to do that. But from where you sit, have trust and faith that there are systems already in place. Your personnel handbook, right, sets up a procedure around complaints of that kind, where it triggers a process for staff, right, primarily through HR and the attorney and manager's offices, to resource an appropriate review of what's going on, right, and handle that administratively. So let that sit there. What's happened in that dynamic, though, is you've heard something maybe that you need to unburden yourself of. And how do we do that? Right? Either contact the mayor, or better, we contact Drew and say, "I heard something about this personnel issue," and he says, "I got it. I got it," and it'll be taken care of. Now, on occasion, there are these high-profile ones where the manager may need to just clue you in or give you a little bit of information about a personnel matter on a need-to-know basis, because they don't want you to be surprised. They don't want you to hear about some high-profile matter from somebody else other than your manager. Right? I don't know. Let's use an exciting example. Maybe manager got a call today, and it was the FBI saying, "Hey, tomorrow the FBI is going to pick up one of your employees on a felony warrant." That sounds like exciting news. Well, the manager may contact you all and say, "Hey, just FYI, but it's not because the council needs to get involved in that actual administration of the personnel matter. It's just to help coordinate communications around those issues." The same dynamics apply to administrative matters. That allocation of authority principle is pervasive. Certain tasks are assigned to staff, and you want to leave those there. From a risk standpoint, we at CIRSA do get concerned, and there ought to be concern both organizationally and from a risk perspective, if an individual gets improperly and unhealthily involved in an administrative matter that's assigned to staff. Right, I'll give you an interesting war story around that. You know, in certain decisions, you make the policy decision and then you're done, and then it's staff go implement this policy. Or you may even, like in a property rights matter, make a decision that says, "Well, we made the policy decision, the council decision, we approved that conditional use or that special use. So we're done with our job. Everything else downstream of there is administrative," right? So you want to let staff do that administrative work. A good example of a war story around this is I had a split vote on a development matter. It was a 4-3 vote, and it was the council's last decision in the process. You know, they gave the development approved or development denied. They approved it by a 4-3 vote. But after the vote, the mayor went to the building department and said, "By the power vested in me as the mayor, I'm directing you not to issue building permits for that development." Good idea? Yeah, I was sort of scrambling to look at the city code and say, well, where does it say that, right? So it's just remember to protect yourself from those kinds of things, and flipping it all around, it means really use your staff effectively, your manager as an effective resource, recognizing that there are certain things that aren't in council's wheelhouse that he'll handle for you, and then there are certain things where he recognizes that they're in your wheelhouse. And his role is just to advise a citizen on process for bringing something to council. And great organizations recognize that and mutually support each other in that distinction between administrative matters and policy matters. Okay. Unless there are any questions around that, I'm going to pivot now and talk about transparency. I'm sure that staff has already done a little bit of tutorial around for the new folks around the Colorado Open Meetings Law. And there's a lot going on in that statute. I'm just going to touch on a couple of things real quick. So remember the basic rule under the Open Meetings Law, right? There's a lot going on, but the core requirement for the council regarding openness is it says the statute says whenever 3 or more council members meet to discuss public business, that's a meeting that has to be open to the public. And that simply means a citizen has a right to observe the discussion. That's it. The other half of that rule is if it's a situation where the council is going to take some kind of action, or there's going to be a quorum there, 4 of you, that meeting has to be preceded by notice and an agenda, which staff takes care of for you. The statute does say that a meeting includes any kind of gathering in person, like we're doing now, by phone or by electronic means. So all these electronic tools that we have, email, what else? Text messaging, right? A meeting can potentially be convened electronically, right? So if 3 or more, that's why staff says, if 3 or more members are using email, right, you do not want to have discussions of public business via email. The concern being is not open. It's not open. So my first handout that I put your places was about email. It talks a little bit further about that risk and makes some suggestions that are purely my suggestions around good uses of email and ones that can have some risk dynamic to them. It's not that we're anti-technology in terms of managing risk. We just need to recognize the risks around those. The statute has said since 1996 that use of email can trigger the openness requirement. But there are certain types of emails that simply aren't subject to the openness requirement. And finally, the Colorado legislature, in this first bullet on this slide last year, went into the statutes and made some amendments that help clarify that. Okay? So if it's here are some examples. And this is for emails, even if all 7 members of council are on the email communication, these kinds of things are okay. If it's only scheduling and availability, right, your manager asks who's available for a special meeting and all the emails are flying around, that's only natural because we want to know each other's schedule. That's okay. If it's purely an FYI email, if it's simply posing a question for later discussion in an open meeting, right? Or if it's just copying your fellow council members on a response that you sent to a constituent, that's okay too, and that's only natural because you want your fellow members to know that maybe you responded because you're not sure whether they got that. But you can see what's going on in all 4 of those situations. There's no discussion among 3 or more council members of a matter of public business. In fact, the other interesting thing the statute did was it added more express language confirming that the discussion of the merits or substance of a matter of public business is subject to the openness requirement. That phrase, merits or substance, what does that mean? Well, the legislature was kind enough to drill down one layer more. Well, merits or substance, that means the discussions of the essence. It's like effervescence or whatever that, but intuitively we know what it is, and we're going to be fine. We're going to self-police on that. And from where you sit, if it's having some email exchange with council members and all of a sudden we've got a 3rd council member on there, and we see, hey, wait a second, this is actually a matter of public business that's on an upcoming agenda, or this is one of our pending policy matters that's upcoming, we need to hold this discussion, right, and have this discussion at our open public meeting, and that'll put you in a safe place, risk management-wise, okay? People sometimes ask me, well, how does this risk actually present itself, and how do people make claims around this? So what happens in the claims world is for controversial decisions, it's quite often the case that people, after the decision is made, will make open records requests for emails. And a lot of times they're just doing that to see if there was any discussion around the issue before the decision was made. And sometimes there is, sometimes there isn't, sometimes there is, and there's no problem under the open meetings law. But sometimes they'll get those emails and they'll see, oh, they'll start putting together the sequencing of who is talking to whom when, and does it look like a discussion was occurring by electronic means. Okay. I said the statute does not apply, it applies to 3 or more, so one-on-one discussions are okay, right? Sure, that's a big part of the job, meeting with your colleague and getting to know each other, right? Getting to know priorities, policies, philosophies, perspectives. So the open meetings law does not regulate one-on-one discussions, and the openness requirement is not triggered by a one-on-one discussion of 2 council members. So that's okay. But what do you think about this decision? One-on-one is one-on-one is okay. What about one-on-one on one-on-one on one-on-one on one? Is that okay? Yeah, the risk issue around that is evolving, but to get to the point, if you get a claim arising from that kind of scenario and the court concludes that the one-on-one type of discussions was a vehicle for arriving at a decision such that the decision is already made And what occurred in the public meeting was a mere rubber stamping of some decision that was already made and some discussion that already led to formulating a position that was just rubber stamped later, then that's a risk under the Open Meetings Law. And there's some cases then that say that's a problem, that's a violation of the openness requirement. One little sidelight on this. We're one of those states that actually does not have a specific rule on one-on-one discussions around this issue. They do have this rule in Texas. They have a rule. It's called the walking quorum rule. I like to work that into my presentation because it's such a nifty Texas kind of, feels very Western. You get a walking quorum, right? Well, their statute actually says that if use of one-on-one communications among elected or appointed officials is undertaken with the intent to evade the openness requirement of their open meetings law, right, then of course the action can be voided. And the Texas legislator said that's a misdemeanor. Wow, holy smokes, right? So the only reason I mention it is we need to recognize as governing bodies and appointed officials that this issue is out there, and we need to self-regulate and make sure we're walking the walk on those issues. Because if the risk gets pervasive or people feel there's a concern going on, then maybe the state legislature is there ready and willing to write some amendments that are going to write the prescription for us. And we all, as local government officials, want to remind them there is not a problem in that area, that we're open, we honor our obligations of transparency. Okay. Who uses, do any of you use social media to do your job as a city council member? No? Do you have personal websites, personal social media sites? You got a Facebook? All right. Sounds like you're in a pretty safe place in that regard. There is a chapter in here that if you are using social media, recognize that if that social media site actually takes on the characteristics of a governmental site, then it becomes subject to First Amendment regulation, and the article in the handbook talks more about that. More practically, if you have a personal social media site, and it sounds like some of you do, and if you want to keep that personal and divorced from your public life, then do the little things that help maintain that separation. Like if somebody sends you a private message or direct message on your Facebook and they want to talk to you as a council member, you have every right to say to them, do you have city assigned email addresses? You have every right, and it's probably good to help you keep that separation to say, hey, next time you want to chat about city business, email me at this address, right? Not on my personal social media page. And that's a good place to be. And there's other tips around social media use here. But we know it's out there, and you see all the headlines around social media. The only other thing I want to mention about social media is, do you follow some of that stuff? Do you have a local social media thread or feed that touches on activities at the city? Some communities have, I think it's called Nextdoor. That's a popular one in the metro area where community members are active and they're talking about city government. That happens, right? And we know that, is it true that sometimes elected officials, appointed officials, and staff can be kind of on the receiving end of less than courteous social media comments? Maybe even downright snarky, right? Or maybe an outright attack. So just recognize that around that, there's this whole continuum of what's going on there. First of all, if that's concerning you, last time I checked, I think the statistic was there's more than 300 million social media posts a day. So don't worry about that stuff. It's just going to roll off, and it's going to be yesterday's news before the end of today, right? If some snarky comment about the city. But on the other hand, there is this whole evolving world of this incivility is kind of rising a little bit. And some of this incivility presents itself in terms of outright attacks on elected officials. So two suggestions in that regard. First, if it really is an outright threat that makes you concerned for your own personal safety or the safety of a loved one or a member of your household, then get some resources to help you think through what are the options, if any, on how to handle that. There is an evolving area of law called true threats, for which we can take action, but we have to be sensitive to First Amendment protections as well, right? And unfortunately, in this day and age, in the social media world, sometimes there are people who are very passionate about what they're doing, and they're very emotional about what they say, and some of the bad actors know exactly where the line is, and they can even attack elected officials via social media, but not step over that line. And in that case, we have to recognize it's free speech. On the other hand, if it's steps over the line and they're threatening someone with physical violence, then law enforcement or the city manager's office might be a resource to help you understand if there's something that can be done. So don't gainsay your own safety and get resources for those kinds of things. All right. Let's talk about ethics just a little bit. As I mentioned, when you got elected, you became subject to the Colorado Standards of Conduct. We don't have all that many ethical scandals in local government in Colorado. They can kind of be fun and exciting to read about when they don't involve us, right? And as the municipal guy, I don't mind reading about ethical scandals in the state legislature or something like that, right? But more seriously, I know that the state ethics standards they're in the Colorado statutes, but sometimes from your perspective seem like they're in this faraway place. And they're written in this legalese, which is like torturous to read, right? But I commend to you, plow through it, ask staff to get you a link or a summary. There's all sorts of good resources around what the ethical standards are for local government officials. Get familiar with the expectations, and I even dare say make them your best friend in terms of preparing you to handle ethical concerns, right? Because one of the most disappointing things that I see when I handle ethics is sometimes something happens, and I think of that Hemingway novel, For Whom the Bell Tolls. It's like the violation occurred, the bell rang, but then we talk to the elected official about the situation, or the appointed official, and say, well, I didn't know that was subject to the ethics rules or something like that. It's so disheartening, because had we known, we could have been prepared, and we could have headed off that issue and made some decisions earlier before the bell rang, because once the bell rings, you can't unring it, right? So find that resource, make it your best friend. The other thing, doing that, we're prepared to spot and deal with issues early before they become a crisis. And then second, we're also prepared to have conversations around ethics. Because I know sometimes, like elected and appointed officials, yes, it's true, sometimes they're going to receive a concern about an ethics issue that might land close to the mark. There might be an issue going on there that requires that we conform our behavior a certain way. But I know sometimes you might be subject to this accusation of a conflict of interest or an ethical impropriety is way off the dartboard. You have a conflict of interest just because you live here. What are you talking about? Right? But when we know, have a working familiar, I respectfully disagree, right? I understand what you're saying, but actually under the code of ethics that governs me as a city council member, I know what a prohibited interest is, and it's, I have to have a financial relationship to the transaction. I don't have any, so thank you. It helps you for those conversations as well. All right. I have another handout in your materials about ethics that I just want to touch on real briefly. And my one-page handout, again, it's not intended as legal advice, but just as a very general resource, touches on conflicts of interest in general and then two other subjects. So you're all familiar, conflicts of interest can be its own session, but we all know when we're in a conflict of interest situation, right? Whenever the council is going to take some kind of official action that directly and substantially affects our own personal financial interest, we have a conflict situation. And we know what our obligations are, right? We have to do what? We have to disclose that we have a conflict of interest, right? We have to recuse ourselves from the council discussion and vote. And the last rail of that is we have to refrain from attempting to influence our fellow decision makers. So a couple of practical pointers around that. Make your disclosure right at the outset. When the mayor calls up the next agenda item, she says, next agenda item is a rezoning, and you happen to be a half owner of the property subject to the rezoning request. Mayor, I need to make a disclosure. I have a conflict of interest, right? I'm stepping off the dais. Right, you all step off the dais. Do you leave the room? Yeah, the state law actually doesn't say that you have to, but I recommend it. Was that a good disclosure? Mayor, I have a conflict of interest, then we leave? Actually, under the statute, it was satisfactory. You disclosed that you had a conflict of interest. But the thing that I found over the years that happens is if that's all we say and we leave the room, then, some of the times, like everybody who's still in the room, their hair is on fire, say, what's the conflict? Oh my gosh, what's the conflict? So use your disclosure, right, to help show your commitment, right, to proper ethical conduct by describing the nature of your conflict. It also has the benefit of tamping down that speculation about what the conflict is. So Mayor, I need to make a disclosure. I'm going to recuse myself from this rezoning matter because I am a half owner of the property subject to this request. I'm going to step aside. That's a great place to be. There is a non-influence provision, so it sounds like you all leave the room. This is one of those things where the grand bargain is being an elected official, you're also subject to the code of ethics. It may sound unfair to you as a property owner that you can't stay behind and advocate for your own interest. But the ethics rules say, right, that you cannot attempt to influence your fellow decision makers. So from where you sit, that's a great time to make sure that you have somebody else, right, be your representative for your interest, right? I hate to see a situation where everything else is done properly, we make our disclosure, we recuse ourselves, but then there's some accusation of improper influence because the official attempted to still participate in terms of answering questions or providing information to staff. Okay. Recognize that financial interest is not only in your own interest, but certain derivative interests, like companies that you own an interest in, holding a position as a director or officer of a business that's in front of the city council, those kinds of things. Or maybe there's no direct financial interest, but you're counsel or a consultant or a representative or agent for a business that's coming in front of city council. Okay. Any questions around conflicts? I know that's a very short snippet. Next one thing I just want to mention is confidential information. This is self-evident, but make sure, right, there's a rule that says do not use confidential information that you learn as a council member to further substantially your own personal financial interest. From where you sit, it's pretty evident, pretty obvious what's confidential and what's not, but if ever there's some ambiguity around that, we just ask. It's probably pretty easy for the attorney-client stuff, right, because your city attorney maybe puts a big red stamp on it or something that says client, attorney-client communication. But there's another world of documents. Sometimes the manager might send you what we call work product, which is like deep background on an issue, right? And if he sends that only to council and it's like for your eyes only, but you're not sure, or are parts of this public, or parts of it not, what am I supposed to do with this document? Just staff will help you with that so you stay out of harm's way. Gifts, the last thing that on gifts, you get a little monthly stipend for being on council, right? That's, yeah, so it's not the lavish salary, and I'm also here to tell you it's not the lavish gifts that bring us to public service, it's love of community. But more seriously, we do have, in Colorado, we actually have a constitutional amendment on gifts called Amendment 41, okay? And there's a lot going on there, but just for purposes of this presentation, I've got just 2 sentences to summarize the rules around gifts, which I'm not proud of because there's a lot of nuances to it, but here's my 2-sentence takeaway. First, don't accept any gift of more than $65 from any one person in any one year if it's in any way related to your official capacity as a council member, okay? Subject to this huge caveat, don't accept a gift no matter what it's worth, right? If it's obvious to a reasonable person that the gift is being offered to you to curry your favor, influence your vote on a matter coming before council, or to reward you for some vote that you've already cast. So those are the 2 takeaways. In practical reality, so much about gifts is just timing and context, right? And we know that. If the timing is odd, the context of the gift is odd, we just say no thank you, right? And lastly, in matters of ethics, recognize that appearances do matter, and there are risks beyond risks of violation that are above my pay grade, but you know that, right? That there could be a residue around an appearance of impropriety. So that's not to lessen the point that in matters of ethics, who's responsible, right? You don't have in your local code any rule that says if one council member says, well, I don't have a conflict of interest, so I'm going to participate. You don't have a rule that says the other council members can say, no, we disagree. We're going to adopt a motion that says you must step aside, right? So who owns the decision in matters of ethics? Each of us individually. Yeah, and then each of us individually has to live with whatever decision we make. But do recognize the potential organizational impacts, because every matter of ethics starts as an individual choice. And then you reach this fork in the road, right? And frankly, from my experience, right, there's always the choice of being conservative in matters of ethics And yes, it may be frustrating where if you've gone through the analysis and determined that you don't have an actual conflict, but you know there are concerns about an appearance of impropriety, well, if you take that fork in the road and you step out, then it remains a personal. The impacts remain personal. I took myself out, right? But in those close calls, if you say, as you have the right to do, you could say, it wasn't an actual conflict. I reviewed the issue. I got advice. I don't have to step aside, but I'm going to participate because I don't have an actual conflict of interest. That can have a broader impact now. Could still impact the council as an institution. Still could be residual concerns, right, about appearances of impropriety. So that's not to tell you which fork in the road to take. It's just to tell you that that's dynamic is out there, and I think is a pretty important one. Before I mention this slide, I want to go back just a little bit and tell you about one handout that I didn't mention during my transparency piece. As you know, as I said, the openness requirement is there and requires we do most of our work in an open meeting setting. But as you know, you're allowed to have executive sessions, right? But only for a limited number of topics and only after you follow very specific procedures that staff's going to help you with. The one handout I left at your place on this was an article talking about some recent decision out of the Colorado courts that emphasized the importance, right, for the body, the council, to make sure that you get all those procedures correct. And I guess from where you sit, if there's ever any concern, like you're queuing up, you usually have executive sessions late in the meeting, right? Near the end. If there's any concern, did we get that right? Did we cover all the points? Then yeah, you absolutely step up and say, staff, have we got that right? Do we need to redo that motion? Yes, please. Council members, please start over. Let's make sure we get it right. One or two other practical impacts on executive sessions is you know that you have to make a recording of the executive session when you're in executive session, right? So we have to maintain that tape for 90 days. It's not available for any purpose other than for litigation in limited circumstances. But when you're in executive session, unless the city attorney asks that the tape be turned off for attorney-client communication, the tape is still on. And what you're saying is being recorded. Now, in legal proceedings, it's very difficult to get a hold of that tape, but sometimes, in some circumstances, that tape does have to be disclosed in litigation, right? So professionalism, staying on point, tact and diplomacy still matter in executive session, right? In my world, you certainly don't want to be the one who's on that recording in executive session whose name is attached to a real zinger. Not a good spot to be, right? So there's some risk around that as well. And then finally, confidentiality, protecting the institution's confidentiality is important. When you break from executive session, maybe a good tool is to say something like, of all the confidential information that we've discussed in this executive session, right, which information, if any, leaves this room and who are our spokespersons? And then that's just a quick way for council to all confirm our common understanding about how we're going to protect the confidential information that was discussed in that executive session. And as fiduciaries, I think we each have an obligation to honor that confidentiality. That's true even if, like, even if you didn't vote to go into executive session. You didn't want an executive session about this matter. Or you can't even stand the underlying idea of the transaction that's going to be discussed. Maybe it's a matter subject to negotiation, right? But even given those dynamics, you have a fiduciary responsibility to honor the confidentiality as identified by the council as a whole. So keep that concept in mind. And that's what this article is about. The one that says public officials liability alert. So ethics are, they're basket in and of themselves, right? But beyond compliance with the code of ethics, right? Recognize that there's this other dynamic around ethics, and that's kind of high levels of personal conduct, right? And just recognize that committing to high standards of personal conduct can have a really positive influence on the council as an institution. By the same token, right? Destructive personal conduct can be very destructive to a governing body and its agenda. I listed on this slide just some of the situations that people have contacted us about at CIRSA. Elected officials call myself or our executive director and say, these are kind of the dynamics that are going on. Are there any magic wands that we can wave and solve this problem? Well, it's a wise counsel right? That if any of these kind of dynamics are going on, it's a wise counsel that spots those issues early, right, and is willing to have the eyes-up discussions around what's really bothering us. How can we get to a better place? Are we all okay and feel like we're in a safe spot to have that conversation to make sure that we don't have issues around personal conduct that are undermining our effectiveness as an institution. All right, my last suggestion is to commit to due process, and this can be a training in and of itself. We're happy to do that for you sometime, but I just want to get on everyone's radar this interesting part of the job that requires us to engage in different types of behaviors when we're making decisions that affect individuals' protected property rights. You know, for a lot of the job, you're just making general policy that applies to no one in particular, right? Only applies to people in the abstract, won't be applied to people until some later date. That's the job of the legislator. And that's part of your job. That's a great part of it. That's probably what you intuitively thought of when you said, you know, I want to be a council member, I want to make policy. Right? Want to articulate vision, want to help drive the direction of the community. Well, at the local government level, you have this other power. It's an awesome power, where you have the right to make individualized decisions that concern people's individual property rights. And at the local government level, that's primarily land use and licensing matters, most of them, not all of them. In that role, you know what that context is because you have a specific applicant in front of you, right? And in that role, you're actually making a decision like a judge. And that's why we call it a quasi-judicial decision. The hallmarks of a quasi-judicial process are the council has this hearing. It's like an evidentiary hearing. We give extra notice to all the individual parties. We have a hearing where everyone gets to provide their evidence and testimony. And then we as a council and as council members are obligated to make the decision based upon the pre-existing standards that are in place, right? Not our own personal preferences, but the pre-existing legal standards. And the decision has to be made by a fair and impartial decision maker. Sounds much different than policy making, doesn't it? Yeah, that's the quasi-judicial role. So you want to become familiar with the due process rules of engagement that require us to engage in the kind of behaviors that judges behave in around those types of matters, right? And do the things that judges do and don't do the things that judges wouldn't do. People ask me, you know, where does all this mysterious new set of rules come from? Very familiar source. No person shall be deprived of life, liberty, or property without due process of law. At the end of the day, for something like a rezoning, do you make the decisions on the marijuana establishments? Council do that? And liquor licensing? Yeah, those matters, a new license application or a rezoning or a subdivision request, right? We want that power to make that decision locally. We don't want the county or the state or some super agency telling us whether this or that development gets approved or denied or whether this or that entity gets a license. We want that local power, right? But with it goes the responsibility to make sure we honor people's due process rights. So the last link on that slide is much more basic training around that. I just have a couple of tips to get on your radar. So in this quasi-judicial role, it does require that we limit our participation to only the council's hearing. This is the part of the job where we have to set aside those types of behaviors that are okay in the legislative role. Like in the legislative role, you can lobby people and be lobbied. You can talk to anybody, anywhere about this legislative matter. You can make the decision based on your own personal preferences. You can do your own research, right? But in a quasi-judicial matter, all of those things would be inappropriate because you're in a judicial role. And I know that's the lonely part of the job. Because what happens in reality, right? I hope not all of your licensing and land use applications are controversial, but if there's a controversial one on next week's agenda, what's the citizen's natural inclination? I want to reach out to my elected official, right? Get in touch with them and, you know, explain to them why they ought to vote yes or no, right? So that's the burden's on us to remind people that in service of the due process requirements, right? It's not that we don't want to talk to you, right? But it's that as the judge, at the end of the day, only 7 people in this community get to be the judges of that particular application. In service of that responsibility, we have to tell people it's all got to wait till the public hearing. What I'm hinting at there is make sure we don't engage in ex parte communications, I'm not sure I've listed that here on the slide, but in that judicial role, you can't engage with one side or the other outside of the hearing. And a good way to unpackage that for people who do want to talk to you, right, is just to remind them, hey, I'm not trying to be difficult or unfair, but look at it this way, dear citizen. You know, if it were your application, would it seem fair to you that I, as a council member, were talking to other people about why I should vote yes or no without you being allowed to hear that? That's why all the conversation goes on only at the public hearing. And staff can support you in that. Let your manager or your planning director run interference for you on those issues. Maybe a citizen wants to peel you off and talk about a land use matter. You can quickly use your manager as a resource and say, look, I can't talk to you about that because I'm the decision maker, but our staff can point you in the right direction where you can learn information about the application, learn the status of the application, learn when the hearing's going to be, that kind of stuff. Okay? The last thing is deliberations do matter for judges. You know, when you have, for the new council members, have you had a public hearing matter yet? Yeah. You know, the public hearing, you've got a nice process to it, applicant presentation, staff presentation, public comment, whatever it may be. Then there's that point when you bring it back to the council for discussion. Very important part of the process. That's where the council is going to deliberate. That's where people in the audience get an understanding of why you're going to make this decision the way you are. The important thing that's going on from a risk perspective is that's when you're making a record, a transcript of the reasons why you decided the matter the way you're going to decide it. And that's actually the one and only record that we have and that we use through the entire legal process. So I encourage deliberations when you get to that point. You know, everybody, whether you have comments or not, that you want to contribute, everybody ought to have the opportunity to make comments during deliberations and feel like they're free to make those comments. And a good tool for deliberation to make sure we make a good record is to use what I call Sam's rule of why. Okay? I'll give you an example of that in action. I'm sorry, I keep asking staff, is it a conditional use permit or a special use permit? Conditional use permit. So that's kind of a nifty little tool under your land use code. It's like these types of uses that, you know, they're not outright prohibited, right? But they're not outright allowed. You set up your land use system to say, we as the city council would like to take a look at that particular use and make sure it's okay within the context before it's allowed. That's what a conditional use is all about, right? So you have quasi-judicial hearings on that. But you want to use the rule of why, whether it's that or any other application, to make a good record of why you're making your decision. So I borrow conditional use because it's got kind of fun and interesting criteria. Say you had your hearing, the mayor says, okay, let's bring it back to council. Who would like to start? Oh, mayor, I'll start. I'm going to vote no because I just don't like it. Not a great start, but we can get there just by using Sam's rule of why, right? We as council members are going to just test each other and inquire of each other and probe each other about why do you feel that way? Sam, right? Why are you going to vote no? Well, I just don't like it. Well, why don't you like it? Well, I don't like it because the applicant didn't contribute to the city Christmas fund last year. Well, staff's wait a second, that's not a criteria. We're going to focus only on the criteria, right? I don't like it because it's too tall. Well, now we're getting somewhere. That's one of the standards that's under discussion. Or maybe it's an even fuzzier criteria. I say, I don't like it because it's not compatible with the neighborhood. Is that one of your criteria? That's a common one, right? And you could just say, well, why isn't it compatible with the neighborhood? And when you keep asking each other, why do you feel that way, you're naturally drilling down to an evidence-based, a fact-based discussion of why council is going to vote yes or no. And that's an awesome place to be. It makes a record, very nice record of how things happen. And I commend to you at that point of the proceeding, have those criteria at the ready. You know, have them and speak directly to them. I'm going to vote against this liquor license because according to our criteria, the applicant must be of good moral character. And based on the evidence that we heard this evening, I conclude they're not of good moral character. In fact, they're a 6-time convicted tax felon is what the evidence said, so therefore, whatever it is, right? And then you're in a good place. All right. Any questions, thoughts around quasi-judicial stuff? Particularly for the new folks, I know that seems like kind of a counterintuitive part of the job, but do recognize that staff is there to support you on these issues and to help you get your footing with regard to what the expectations are around that process, right? And from where you sit, never inappropriate to ask that question in a quasi-judicial proceeding around what's our process, or what are the criteria, or how do we interpret this rule, or what's expected of me as a quasi-judge. Those support resources are there for you. All right, let me aggregate everything up and just make a couple of final closing comments. Commit yourself to embracing wise leadership as a council, right, as an institution of council and as council members. Commit yourself to a no surprises approach with each other, right? That meetings and meeting dynamics ought not to have this gotcha feel to them, or certainly should not be staff bashing. We all know that we have matters for staff. Are they matters for council discussion? Even if a citizen comes up and wants to make a personal attack on an employee, we have ways to pivot off of that, right? And we can ask people to recalibrate and engage in proper decorum around those issues. I should have asked this, by the way, how are your public comment periods going? Good? So? Good? What's that? Depends on it. Your rule is when I come up for public comment, I've got how much time? 3 minutes? Yeah, you got the nice tool here that helps people understand when their time's up. Is there any limitation on what I can say during public comment? Generally not.
Just be respectful.
Yeah. Well, what if it's one of those situations where we know, oh boy, here's Sam again coming up to the podium, right, next speaker, and 20 seconds into it, we're like, well, this isn't going to go too well. Like 20 seconds into it, the person, I hate local government, and you're all crooks and liars, and blah, blah. What's going to happen next? They got 2 minutes and 40 seconds more to say whatever they want to say. Right? And when they're done, just, okay, thank you, next. Sometimes I call it, when somebody's coming in during public comment, I call it they're coming in hot. And they're emotionally charged, and they may have good reason, or they may not. But they're ready. And sometimes it presents itself as a question or a challenge. Even personally, they want to make a personal challenge to you. What are we going to do with that one? I find in my experience that if someone comes in hot like that and they demand an answer or want something, there's usually nothing we're going to say in the moment that's going to satisfy them, right? And so in terms of controlling the flow of your own meeting, you're probably better off just letting it roll off, right? But do you have your own norm of conduct around, do we as council members, can I as a council member, if a person during public comment says something and I want to respond, can I respond? Mayor, I'd like to respond to that public comment. Yeah. It's your, ultimately you get to decide how you want that flow to go, but among tools and tactics that we suggest, if you are concerned about that dynamic and you can just have a rule that says, or a protocol that says, look, this is public comment, this is your turn to give us information that you have. We as council typically don't engage in back and forth during public comment, but if there's a question raised, either we as a council member or maybe staff's taking a note, and we might address some questions if they're pertinent for this evening at the end of public comment. Otherwise, you could have this dynamic where you thought you had 15 minutes worth of public comment, but because of the back and forth, you end up an hour into it, which you can have if you want, right? But that's just one of the tools we see around that issue. It ties into one of the suggestions on this slide. Recognize that no matter how divisive the situation or citizen coming in hot, right, that recognize that tone and temperament and courtesy and tact and diplomacy do matter. It's not all risk situations, but sometimes they do influence risk, particularly in civil rights claims, right, where a citizen believes that somehow the government overreacted or acted out of ill will towards someone. The word they're going to use in the legal realm is retaliation, right? That those risk profiles sometimes can be influenced negatively if there's the facts suggest that there was some whiff of retaliatory motive. So I know it can be tough sometimes. You can feel like you're really under the, people are coming in hot. But you all have the power and the tools and the skills to deal with that, to bring the temperature down. If it's a really bad situation, you have every right to take a recess. I hope you never face this, but on the Front Range, we had some meetings that got so out of control that we not only did we take a recess, we adjourned and went home. But that might be a better place from a risk management standpoint, right? If you can't do your business because the meeting is devolved into complete disruption, maybe you're better off from a risk profile just saying, well, we've gotten to a point where council can't do its business, so we're going to adjourn for this evening. Again, that's very few and far between, but I think a recess, sometimes there are people, I don't know if they've ever come around, but they will during public comments try to get very close to that line. And they know what their free speech rights are, and they're very valuable and important rights that they have, right? But they may get very close to the line trying to push a button. So we need to be careful, and staff's going to help you with that issue, okay? Commit yourselves to dealing effectively with discord. I handled that on an earlier slide, but it is a wise body that recognizes, right, wherever it's coming from, even, you know, the single member raising a concern with something, is this the time where we need to find the right time, quiet time to talk eyes up about some discord? Because we can have disagreements without being disagreeable, right? And we don't have to let disagreements or split votes drive our agenda or how we relate with each other. Local government in Colorado by law and by tradition is nonpartisan, right? So whatever incivility we sense is out there at the state and federal level around political issues, you don't have to let it invade your workings as a council unless you want it to, right? And then you've got all those issues around that. But it's a wise council that, you know, Eyes Up talks about issues of discord if they're having that. And then finally, taking it all the way back up to my opening slides about within that organizational pyramid, right? Commit yourself to effective leadership at the governing level. Have trust and faith in the system where your administrator is there as your point of contact and accountability. For administrative matters, right? And always remember that you're the stewards of the city's best interest and assets. I did want to make one other comment about the policy administrative dynamic between the council and the administrator. And that is, you do want to commit to speak with one voice to your manager, right? That ain't easy all the time, right? But that's okay. You know, sometimes you may be a dynamic where the mayor says, well, you know, council, great discussion. We need to give our city manager some direction. Let's do that. You got one idea of direction, you got a different idea, you got go down the dais. We got 7 different ideas of direction. We say to our city manager, have you got your direction? Oh. Yeah, maybe. Well, how late is it? Something like that. But who owns that issue? You as a council, right? And you want to own that issue. You don't want to leave that lying, right? When you commit to speak with one voice as a council, that's where you get clarity as to what your direction is. You get accountability, right? Because your managers will tell you, right? And your direct reports are accountable to the voice of the council as a whole, not to individuals, but to the council as a whole. So you don't want to conscript staff either into resolving those issues at the governing body level, but use council no matter how difficult it may be. The mayor, in those dark arts that the mayor exercises so well, may see after that discussion, well, this seems intractable. We're not going to get to that direction tonight, but let's commit as council to come back at the next work session, our next meeting, and talk more about this so that we do give clear direction to our staff, and that's going to serve you very well. So that's a great place to be. And then trust that your staff within the, we call them executive limitations, some like consultants will say, within the executive limitations that you've set at the policy level, they're responsible for taking care of the day-to-day work for you. So use that effectively to your advantage. Always keep in mind that you're the stewards of the best interest and assets of the city, and with that, you will do, as you are doing, do wonderful things for your community and for the city. So, Mayor and Council, I'll open it up to any questions that you might have. I do want to thank you all very, very much for having me down. Wonderful to get out of the metro area and come visit you all. So, with that, I'll open it up to any questions. Thank you.
I just have a really quick question. Could you give 2 examples of a quasi-judicial item that would come before us?
Yes, and I'm going to ask the city attorney to help me, but if I don't have it right, but a rezoning, request for rezoning is going to be quasi-judicial. You're going to have a hearing before council, right?
Correct.
Okay, and then conditional uses. A request for approval of a new marijuana license would be a quasi-judicial proceeding. Are you actually then, you not only have the power to grant those licenses, you have the power to take them away?
Yes.
Yeah, so when you're presiding over a revocation proceeding as well, those are probably few and far between, but if you're the authority, the body that sits in judgment of revocation of a liquor license or a marijuana license, that is also quasi-judicial. Yep. And there are tools, I'm sure staff's got tools, maybe on an advanced agenda or a future work plan list, they can help you identify what are the quasi-judicial matters so that our radar's on early. Right? Sometimes it's as simple or natural as, someone wants to peel you off because they know it's upcoming and they want to get your views on it. So staff can help you have those things on your radar so that you know you've got an upcoming hearing, and then you know that, hey, this is the point in time where I need to remain detached and neutral and not engage in this conversation until it's ripe, until we're at the city council hearing. Any other thoughts that staff wants to add on how we identify and manage those kinds of things?
I would just add that I always look at it, if the topic that you're going to be voting on is going to impact citizens as a whole or a large group of people but not individual property owners, then that's going to be legislative. So for example, if you're adopting a zoning code amendment that amends the procedures by which a rezoning would occur, that's legislative because you're not dealing with a specific property, you're dealing with a policy issue that you're going to be putting into the ordinance. If you're rezoning a specific property, then that's quasi-judicial because it is applicable to an individual or a group, a specific group, and not the population as a whole.
Thank you for the question. Thank you very much.
Well, thank you so much for your time, Sam, and always an informative presentation. And
Thank
so
you,
we
ma'am.
really appreciate also the resources that you've provided for us.
And in the slides, which are also, I think, in your packet, there's some more resources and some links there, including to www.sursa.org, where we do have a couple of dedicated pages to resources for elected officials. So if those are of interest to you, they're there, and thank you very much.
Great. Thank you, Sam. Thanks for coming all this way.
My pleasure.
All right, we'll move on to C on our agenda, general council discussion. Do we have any topics that any particular council member would like to bring up? All right, seeing none, then we'll adjourn this meeting until 7:30 for our regular meeting.